he has some specific needs based on a past illness.
However, what she's done is she's filed a false address with the court saying that she lives in Blanco.
I am a licensed professional counselor supervisor for diagnosis. It was the adjustment disorder, which is F4322. Clothing was being withheld so that no clean clothing was being provided during a period of time when Emmett was experiencing illness. That
it was your position that my client is calling him in the middle of the night and waking him up to take a picture of him in the middle of the night.
No, I have not ever called him during that time. I did. He had extreme exhaustion. More in the beginning, he was coming back without underwear.
Oh, and I understand it's Ms. Serrano's motion to reconsider that we're here for this afternoon?
That is correct, Your Honor. We're here on the motion to reconsider, which also incorporates the motion for you to confer with the child, who is 13.
Okay, you may proceed.
Thank you, Your Honor. And before I jump in, I just wanted to clarify, previously we've been told that any time you spend conferring with the child would also be part of the 1 hour session. Is that still the case?
That is definitely true, that if there is a interview or conferring with the child, it comes out of your time announcement. But I mean, are you asking me to reconsider something? Was the child over 12 at the time of the motion that's being reconsidered? Because if not, okay.
He was, Your Honor.
And did you ask for conferral then?
No one had requested the conferral until I was on the case. The motion I had filed, I believe, was back in October or November. And
okay, well,
hearing was
that's
prior.
You're not asking me to reconsider then. You didn't ask for conferral then, so I don't believe you can add one now after the fact. That's not a thing. But you can lay out your argument and I'll listen. You may proceed.
Thank you, Your Honor. I would call Miss Tony Davis as my first witness.
Your Honor, could we give an opening argument at all?
That would be helpful for me. Mr. Jeffries, it's been some time since the court heard this case. I've been on the bench all day on other cases, so it would be helpful for you to refresh my recollection about the status of this one.
Of course. I'll kind of brief it down for you, keep it very simple. When it comes to this child, he's now 13 years old. He has some specific needs based on a past illness, and we're asking the court to reconsider certain of its orders in order to have those more properly met. A lot of the allegations you're going to hear from each of the parties concern things that the child is doing or saying or how he's behaving in their possession. And that's part of why we've asked the court to consider and confer with the child regarding what he has to say himself, because that's going to be the best source of information. We have the child's counselor here to testify as well, who can say what she's been observing, what the child has reported to her in part. And overall, you're going to hear that the temporary orders should be reconsidered in certain portions.
Okay, thank you. All right, Mr. Willie.
So, Judge, the essence of this, and if I can play it out for you, is you have a child that was semi on the spectrum. There was some evidence of some alienation, and you ruled that dad should have a standard possession order, at which time we elected under Family Code 153.317 to expand that and do an expanded standard. Mom has moved since temporary orders, actually since January, at least said, and what we've tracked 5 different times. They were doing the expanded from September until about December. And then Mom sent a message that I have that says, I'm over 50 miles and therefore you can't do the expanded anymore. Well, that's not the law. The law is over 100 miles. But the thing that's of significant concern is 2 things. The alienating behavior continues. She switched lawyers. She has a right to do that. However, she filed a CPS report, or somebody had filed a CPS report based on allegations. That was denied. That was after your ruling. She's refused to give us her address. And as of late, the most concerning part of this is somewhere in her mind or attorney's mind thinks that the magic number is 51 miles and you can't order expanded standard after 51 miles, which is not true. However, what she's done is she's filed a false address with the court saying that she lives in Blanco, which happens to be 51 miles by how the crow flies. Driving is 62 miles. And the reason I know she's filed a false address is because she's still living at where we suspected her to live is out in Bastrop, and that's 48 miles. How do I know that? We took my client knows where she lives through because of the kid's iPad, took pictures of the car as of yesterday. So she's doing anything she can. And by the way, they didn't call the counselor the first time to have you not order an expanded standard. And under my reading of the code is he has absolute right to do that once you order a standard without any other findings. So I think this motion should be dismissed. I think she should be truthful about where she's really living. And my gentleman should get back to what he had for the first 4 months until he got Mr. Jeffries, who filed a motion to reconsider, I believe, in January. And I think the essence of their argument is it's not good for the kid. The kid is homeschooled. One of their arguments at trial is he has all these therapies and he can't go over to dad's house. Well, she quit every therapy after you made your ruling, except for this counselor that is coming, which he took 3 months off and then went back. So, major concerns here, Judge. I know we can't address them all, but I think we had sent in an order that encompasses the election and the expanded standard. We'd like to stick with that and move on this case.
Okay, Mr. Jeffries, you may proceed.
Thank you, Your Honor. My first witness will be Tony Davis.
All right. Ms. Davis, you can unmute. If you would raise your right hand. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I affirm.
Go ahead.
Ms. Davis, can you please state whether or not you have any professional qualifications?
I am a licensed professional counselor supervisor and a registered play therapist supervisor.
And how long have you operated in those roles?
For 13 years.
And what is your educational background?
I have a master's degree in clinical mental health counseling from University of Mary Hardin-Baylor.
So how long has Emmett been a patient of yours?
Care with Emmett was established in the beginning, so October 8th of 2025 is when the initial session was had with Mom, with the initial session with Emmett on the 14th.
And what is the basis for which Emmett is your patient?
Judge, I'm to object to any further testimony by this witness. Your hearing was in September of 25, and so this would be new information, not a reconsideration.
Mr. Jeffries, what's your response?
In general, I think new information leads to the reconsideration. Yeah.
I think that would be further temporary orders.
Brief response on that, Your Honor, is we can call it whatever we'd like to, but we're getting to the same place.
Well, you called it a motion for reconsideration, so that's all it is. Those are two separate things. I'll overrule the objection, but go ahead.
So, Ms. Davis, what is the basis for which Emmett is your patient?
Emmett was established in care for coping with the recent changes with custody and visitations.
And how many sessions have you had with him thus far?
23. 22 with him, 23 including the intake with Mom.
So during that time period, you've gotten to know him and his living situation?
Yes.
And does that encompass his living situation at his father's house and his mother's house?
Yes, he does talk about both.
During the time you have seen Emmett, have you made any diagnoses regarding him?
At the very beginning, for diagnosis, it was the adjustment disorder, which is F4322 of the diagnostic code manual for DSM-5, adjustment disorder with anxiety, as to the anxiety that he experienced with the transitions and the changes was very much the concern being presented.
And in terms of, let's say, Emmett's health background, are you aware of what that is?
Yes.
And could you describe that for the court?
Judge,
I'm
I'm
aware.
going to object to any hearsay she's about to testify to.
Okay. Ms. Davis, you can't tell me what the child told you or what the mother told you.
Okay. I only know through statements from mom and Emmett.
Then the objection's sustained.
So, as Emmett has been your patient, has he described any personal difficulties he's had with
Judge,
either parent?
Judge, I'm going to object. That's hearsay. He's asking what Emmett has described.
What's the response, Mr. Jeffries?
We're looking at a state of mind.
Once you rephrase the question.
Ms. Davis, has Emmett ever described his, in any format, his relationship with either parent?
Same
Yes.
objection, Judge.
Sustained.
It's hearsay.
Sustained.
Is part of your role in this matter to diagnose Emmett and treat him?
Part of my role is to provide treatment. Yes.
And is diagnosis part of that?
Diagnosis is part of that, particularly regarding towards insurance purposes. And so diagnosis for other issues would probably be a more specific assessment.
So you stated that you had diagnosed Emmett with adjustment disorder with anxiety. Is that correct?
Yes, sir.
And what statements led you to believe that that would be an appropriate diagnosis for Emmett?
Judge, I'm going to object. That's hearsay statements.
What's the response, Mr. Jeffries?
Any statements that were provided to her for the purpose of a medical diagnosis are an exception to the hearsay rule.
And they have to be statements that were provided for medical diagnosis. So I'll overrule, but you have a very limited latitude within that frame of reference.
So, Ms. Davis.
Per the diagnostic criteria of adjustment disorder with anxiety, Emmett had been experiencing struggles with anxiety following the recent changes that had occurred within the past 6 months regarding the custody, and that his anxiety had been impacting his day-to-day life.
So these feelings of anxiety, have they improved over the past few months?
Based on the report of Emmett, they have not.
And in your professional role, you are a mandatory reporter, is that correct?
Yes, sir.
And at any point, have you had to make reports to the state regarding Emmett?
Yes, sir.
When was that made?
I believe a report was made, in the beginning of November. And then I believe another report was made after that point, but I don't remember the exact date.
So just for clarity, those were reports made by you.
Yes, sir.
What was the reasoning for you making those reports?
The reasoning for the reports was information provided by Emmett regarding situations that occurred during visitations with his father.
What information was provided that led you to make those reports?
Judge, I'm going to object. It's hearsay. Plus, this has all been ruled out already. We have the letter with us.
Okay. Mr. Jeffries, what's the response?
Part of the part of the information that Mr. Willie tendered in his opening and that has been provided by Mr. Curiel is that my client is trying to alienate him from the child, that she is making CPS reports, and Ms. Davis is a mandatory reporter. She is saying she is making these reports, and I think the basis for why is pretty important when it comes to this child.
So you're not offering for the truth of the matter?
We're not offering it for the truth. We're offering it based on what the child is telling, so that Ms. Davis has to then react and make the report. So words, legally significant words in that sense. So no truth, legally significance.
I think it's irrelevant. It's already been all ruled out. The investigation is done. I think mom is.
You're talking about the conclusion, Mr. Willie?
Yes, ma'am.
Okay. I'll overrule the objection.
So
Ms. Davis, what was said to you that, go ahead.
the statements made to me included the fact that clothing was being withheld, so that no clean clothing was being provided, that during a period of time when Emmett was experiencing illness, that care was not provided given previous concerns of his medical health. And then a separate report was made with the concerns of not adequate nutrition being provided because food was not adequately being provided.
Were there any other statements that led you to make these reports that you made?
There were not other statements that would register as a CPS report. There were statements that in following up with CPS were additional concerns for having supports for Emmett.
I'll pass witness.
Ma'am, who was the counselor prior to you?
I am unaware.
You're unaware whether or not at the time of the hearing there was a different counselor in September before you?
I am not aware of the previous counselor's name. If there was a previous counselor, then that person's name was not provided to me.
Is it standard to ask that and perhaps review their notes?
It can be standard to ask that to ensure that there is not co-counseling going on to address the same issue at the same time.
Mm-hmm.
Some people can choose whether or not they want to provide a release of information for a previous counselor or any other entity, and it is to the discretion of the client or their caregiver to do so.
Okay, so mom didn't tell you that there was a previous counselor at the time of the court hearing?
I was informed that Emmett has previously had counseling.
Okay, but you didn't ask who it was?
I was not informed when timelines for counseling were given.
That's not what I asked. I asked, you were not informed who it was?
I was not given a specific name at that time, no.
Okay. You're familiar that the CPS allegation has been ruled out completely?
Yes.
Okay. What do you think the impact of 5 different moves since January might have on Emmett and his stabilization?
Checked assuming facts not in evidence.
Well, hypothetically then, until it gets in evidence.
Overruled. You may answer.
Any changes can impact someone. How they adjust to a change varies depending upon the supports they have where they are for a change.
Do you keep a file on Emmett and his mother?
I record session notes based on each session I have with Emmett.
Do you have their address?
I have the address on file from when care was established.
Okay. And has that address changed since?
I am aware of a move that occurred since then.
And what is that address?
I do not have that address at the moment.
So if you're aware of a move, you didn't ask for the updated address?
I did not have the updated address provided at the time, no.
Okay. Did you ever reach out to Mr. Curiel as the father?
I have not spoken with Mr. Curiel, no.
Okay. Do you know that they're joint managing conservators in this case and they have to make decisions regarding counselors together?
I am aware they are joint managing conservators from the temporary order I was provided. It also stated that each person was able to consent for treatment independently.
That's what you think it says?
That is how I read it.
Okay.
I am aware that Ms. Serrano did state that she provided my information to Mr. Curiel as well.
Okay. And you didn't think it was important to reach out to Mr. Curiel?
I had not reached out to Mr. Curiel, mostly because I was waiting to see what Mr. Curiel wanted to do at first.
Okay. That's all the questions. I'll pass the witness.
Anything else, Mr. Jeffries?
Yes, Your Honor. Thank you. Did Mr. Curiel ever reach out to you, Ms. Davis?
No, sir.
I'll pass the witness.
Okay.
Nothing further.
I think that concludes your testimony, Ms. Davis. You can put yourself back on mute. And you can be excused unless counsel has asked that you remain.
We have no objection to her being released or anything.
Okay. Ms. Davis, you're free to exit the virtual courtroom.
Thank you.
All right, Mr. Jeffries, do you have any other witnesses or evidence to offer in this proceeding?
I do, Your Honor. I'd call Mr. Curiel.
Okay. Mr. Curiel, if you'd raise your right hand and be sworn. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, counsel.
Thank you, Your Honor. Mr. Curiel, how are you currently employed?
I am working at 2 gyms, and I do cooking at a farmer's market.
So how much currently is your monthly income?
Judge, I'm going to object just for relevance. I don't think they've asked to reconsider the child support.
Mr. Jeffries, what's the response?
I have received pay stubs from back in, I believe, in July is the latest one I have, and it shows that Mr. Curiel's income is about $300 or $400 per month, and I just have a hard time believing that, and I have to actually include an amount for child support in the temporary order.
This isn't a temporary orders hearing.
Right. I'll move on, Your Honor.
Okay.
So, Mr. Curiel, how often does Emmett call his mother while he is in your possession?
He would call when we first started Friday, Saturday, and Sunday night. After a couple weeks, it began to go Thursday, Friday, and Sunday. Up until she changed that I couldn't see him Thursday through Monday. It had gone back to Thursday, Friday, Saturday, Sunday, or actually Saturday, not Sunday. And then she's asked to continue calling. So I've changed up until recently to just Friday. Just Saturdays.
Okay, so my actual question, how often does Emmett call Miss Serrano?
I'm sorry?
How often does Emmett himself call Miss Serrano while he's in your care?
Oh, sorry. He's never called up until recently, this past Friday.
So you're aware that you filed a response to this motion.
What? I'm sorry.
Are you aware that you filed a response to my client's motion?
Yes.
And in that response, you allege that he was calling his mother often.
No.
I don't believe I did.
You allege that he was calling his mother during church.
No, I didn't.
Oh.
But she did ping him through the angel sense.
So, Mr. Curiel, if you swore under oath that he was calling her during church in your response, that's true or not?
I'm not sure. I just know that she had pinged him at the church.
Okay. So you do recall filing a response to my client's motion, though.
And what's that response?
Okay. I'm going to move on.
Thank you.
How often do you attend Emmett's doctor's appointments?
I've never attended doctors. I've tried to talk to the doctors, but they refuse to give me information.
Okay. So you've never attended a doctor's appointment?
No, I've only attempted one therapist appointment after the judge's ruling in September, and I was met with both Elizabeth and her mom, Marjorie, and that was the last time.
So objected non-responsive at this point.
Overruled.
So, Mr. Curiel, how often do you leave behind the devices that Emmett uses, his Angel Sense device, for example?
Maybe like once or twice. We've forgotten it.
And how often do you leave behind his speech device?
I asked him if he wants to take it, but he never takes it, so we just leave it at home.
So it's your testimony that Emmett is telling you he doesn't need it.
Correct.
Okay. That's what it is.
Judge, may I share my screen?
You may.
I think I did something wrong here. Can you help me?
The green button at the bottom that says share should,
I did that, and then it said iPhone mirroring for some reason. Let me see if I can cancel that. Nate, do you see the green button at the bottom? No, because you have to. Oh, there it is. It's okay. Sorry, Judge. I'm on a different computer. Mine wasn't working. Share window, I guess. Yeah.
might need to share the other
s-
screen that the Zoom isn't on. There you go.
Is that work? You're able to see that?
Yes,
Um,
your inbox.
okay, great. Thank you. Mr. Curiel, you, after the hearing in September, ruling in September, you exercised what we call an expanded standard possession order for about 4 months. Is that right?
Yes.
Okay. And then in January, I'm sorry, wrong one. In January 5th, is this a text from Mr. Morano saying that she moved over 50 miles and you no longer get the expanded standard?
Yes, correct.
Sorry, it's Friday, December 19th. And you asked her the address
Yes,
where
I have.
she is? Did she provide that to you?
No.
Okay. Here I'd like to introduce Petitioner's Exhibit 3.
Any objection?
No objection.
P3 is admitted.
And I even shared with you that I asked the lawyer for the address and they didn't respond to that. Is that true?
Yes.
Object to hearsay.
I can move on. Did
Also,
they file? Sorry. Did we get a filing last week that listed her address as 895 Ranch to Market 32, Blanco, Texas 78606?
Yes.
I'd ask you to take judicial notice of the entire file.
I will.
Do you believe she's living at 895 Ranch to Market 32, Blanco, Texas?
No.
Where do you believe she's living?
I believe she's in Bastrop at the 144 Blackberry Lane or Hackleberry Lane.
Okay. And how did you find out that she didn't give you her address, how did you know that she was at the 144 Hackberry Lane?
Well, Emmett has Find My on his tablet, so we went on his Find My, and it shows where the mom is at all
Object to
times.
hearsay.
So that's how we found out.
Okay.
Sorry.
Overrule the objection.
So
Have you?
sorry. So we.
Let me ask you another question. Have you been out to 144 Hackberry Lane
Yes,
on how many occasions?
I believe total of 3.
And when's the last time that you went out to this address?
Just yesterday.
All right. And what did you observe when you got out there?
I just saw the vehicle that they drive in, parked in front of the house.
Share this. February 28th, you went out there. Is that their vehicle?
Yes.
March 15th, is that their vehicle?
Yes.
And then it says, this picture, when was it taken? It says today,
That
120.
was yesterday.
Okay. Here, I'd like to introduce Petitioner's Exhibit 7.
Any objection?
No objection to the photos.
P7 submitted.
So after she filed with the court saying that she lived in Blanco, she's still living in Bastrop?
Yes.
Object to calling for a conclusion.
Overruled.
Does she ever let you come to the house to pick him up, or does she make you meet different places?
No, she's never had me come to her address since she had moved back in late December, I guess. But
Okay.
ever since she moved, when she refused to give me the address, I met with her at a bunch of places in Lakeway, down South Austin, and now currently we've been going to Goodwill in South Lamar.
Okay. And significantly, the 895 Ranch to Market, is this a map we put together to show the judge how many miles it is? 62?
Mm-hmm.
Here, I'd like to introduce Petitioner's Exhibit 5.
Any objection?
No objection.
Admitted.
And significantly, Petitioner's Exhibit 6 on Hackleberry Lane. In Bastrop, that's 47 miles, correct?
Yes. And 38 if you take those back roads, which is what I took.
Okay. Well, regardless of how far she is, she's under 100 miles, right?
Yes.
And do you want your court order signed that allows you to elect the expanded standard possession order?
Yes.
And so, are you okay with meeting somewhere still, or have the court designate one spot? Because he's homeschooled, correct?
Yes.
Okay. Are you okay? Do you want to go to the house to pick him up, or do you think the court said last time a central meeting spot?
I think a central meeting spot is better.
Do you have any suggestions if she's really living in Bastrop where that central meeting spot would be? Okay, you don't. All right. March is P9. Is this the closing report from CPS?
Yes.
Okay. And you're like to introduce petitions exhibit 9.
No objection.
It's admitted.
And just for the court's recollection, Mr. Curiel, you have another son that lives with you, is that right?
Yes.
And his mother just passed away.
Yeah, she passed away September 30th.
And what is his name and how old is he?
His name is Nicholas Currio, and he is 9 years old.
Okay. And do him and Emmett get along well?
Yes.
Okay. And you obviously have custody of him full time.
Yes.
And the lady that was on the screen now, I don't see her, but that's Christy. That's your, now I see her. Christy, that's your wife.
Yes.
Okay. Do you feel you're able to maintain and take care of Emmett if the judge allows you to make the election for the expanded standard possession order?
Yes.
Okay. Judge, I'll pass the witness.
Okay. Are you still screen sharing, Mr. Willie?
Yes.
Okay, if you would turn that off, and Mr. Jeffries, you may.
Did that work?
Yes, it did work.
Yep.
Okay. Thanks.
Thank you, Your Honor. So, Mr. Curiel, what are Emmett's needs right now as they pertain to what are his physical needs that go beyond a normal child?
I mean, he just needs a lot of attention especially when we're out and about, making sure he's getting around places. I've been taking walks with him every night to kind of keep his feet moving.
What time does he go to bed at your house?
So Elizabeth usually calls him around.
Objection
9
unresponsive.
I'm sorry.
Oh,
She normally calls him around 9 p.m. and we get him to bed a little bit after he talks to her, he takes a shower, and then usually around 10 p.m. he's in bed.
And to your knowledge, he sleeps through the night?
Yes.
Have you learned recently that may not be the case?
No.
Your Honor, I'm going to share my screen real quick here.
that's fine.
Wrong one. So, have you seen the photographs that I have marked as Exhibit M1?
Yes, I've seen all these.
And these appear to have been taken at various times of night. Is that fair to say?
Yes.
And these are on days when Emmett was in your possession.
Yes.
So is Emmett reporting to you that he can't sleep?
No, he doesn't report to me saying he can't sleep.
So were those photos surprising to you?
It did at first until I realized what was going on, but which is part of the reason why We have kept the angel sense out of his room because I believe that she pings him in the middle of the night just to take those pictures. So ever since we've done that,
Okay.
we've kept track of him through the night and he sleeps through the night.
So it's your position that my client is calling him in the middle of the night and waking him up to take a picture of him in the middle of the night.
Well, he's taking a picture of himself, yes.
Okay, so just so I'm clear, your position is that my client calls Emmett in the middle of the night so Emmett can take a picture of himself in the middle of
That's
the night?
what I believe. Like, especially if you look at those pictures, that does not look normal.
Okay.
Looks like
Objected,
he's you do
non-responsive.
that.
Sustain. Wait for a question.
Okay, and I'll pass the witness.
Anything else, Mr. Willie?
No.
Okay, Mr. Curiel, you can put yourself on mute.
Okay.
Any other witnesses, Mr. Jeffries?
At this time, I'll call no other witnesses.
You're not going to call your client?
We can, yes. I'm more curious about the timing if we're going to be interviewing the child.
Well, this is set for an hour. You're rapidly running out of
Right.
time. And I mean, I think I made myself clear earlier, but you didn't request that the court confer with the child at the time of these hearings. So I don't think a motion to reconsider, you can suddenly include a new request to confer, not as a part of a motion to reconsider.
We have filed a separate motion as well, Your Honor, prior to filing a motion to reconsider. I believe both were set today.
I don't think that's what happened. I think the one was set, Judge, and you would then perhaps take it. You would make a ruling on the rest.
Okay. My docket sheet indicates that the motion to reconsider is what's said, but hold on a second and let me double check. Okay. Yes, I confirmed with my staff while you sent the court a copy of a motion to confer. The only setting for today is on the motion for reconsideration. So,
In light of that, Your Honor, I would urge the court to exercise its inherent discretion under 153.009 and still confer with the child.
well, it's a school day. I assume the child is at school or the child is homeschooled.
He is homeschooled, yes.
Okay. Well, it's not set today, Mr. Jeffries. We have rules. And if I start ignoring them for you, then that means other people are going to want to have the rules ignored. So hearings require notice. You don't have a setting, so you haven't given notice. It's just not something I'm going to take up today.
Thank you.
Also, you have about 10 minutes left, so I'm not sure that there's really an opportunity for meaningful conferral, and you haven't closed argument on the motion in front of the court today. So,
Thank you, Your Honor. I will call my client then.
okay. All right, Ms. Serrano, if you would unmute yourself. You swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Go ahead.
Ms. Serrano, currently, what possession schedule is Mr. Curiel exercising of Emmett?
Currently, he's exercising a possession schedule where he picks up Friday at 6. He drops off Sunday at 6.
And that's on the first, third, fifth weekends of the month.
Yes, it is, including his holidays.
Okay. So has Mr. Curiel exercised all of his possession pursuant to that schedule?
The Friday through Sunday, yes, he has not exercised all of his holiday time.
When you say he hasn't exercised all of his holiday time, which ones has he missed?
He missed his Christmas possession.
So as we sit here now, what changes in demeanor does Emmett exhibit when he returns from Mr. Curiel's possession?
Extremely exhausted, to the point where when he did have possession during the school period, he was not able to complete school period with his teacher. He is homeschooled, but it is a online private school that is accredited. So it is not me teaching him through books. He has to pretend, he has to confer with the teacher, he has homework. Mhm.
So when it's with you, does he have access to his Angel Sense device as well as the speech device at all times?
Yes, at all times they are with him.
And are those still required at this time as
They are
per the
still
recommendations
required.
of the
Oh, sorry, go ahead. Mhm.
and that's in accordance with the recommendations of the relevant professionals?
Yes, he has a current speech therapist that is working with him with the device to help him formulate sentences because he knows what he wants to say, but sometimes it is hard to get out due to his brain swelling injury that occurred back in January of 25.
So what physical issues does he have at present?
At present, he has difficulty with rapid movement, which is running, fast walking. He has some cognitive delay. He was on the spectrum before, but after his recent brain injury, his cognitive delay has been a little bit more difficult. So taking more time to talk, taking more time to explain things. He does need assistance with, sometimes he needs assistance with going to the bathroom. Sometimes he needs assistance with the shower. So these are things that have happened more recently. Mhm.
And when did these physical limitations begin?
The more physical limitations like this were after his hospital stay in January when his brain was swelling. Before that, yes, he was on the spectrum and he was, had delay in some of his academics, but he was very active physically, very, like aware. So he still hasn't reached back to what his doctors would call his complete baseline yet. Mhm.
So as part of his autism, what steps are taken to help alleviate that? Any of the
So
issues with it?
the steps that are taken that I take, we have very low lighting in the house. We have, he can have his tablet for certain things at certain times of the day. It is really used as just as something that he can use in case he gets anxiety. He also has fidget spinners available during school, during class. I've spoken with his teachers at times when he does get overwhelmed by noise or overwhelmed by what's going on, that he can turn off his camera. He's allowed to take some breaks at times when he needs it. When we are out, I am typically, you know, um, I'm walking with him and making sure he's on that front, that he can walk with me. He has recently gotten better though with his speech and some of the things that he is able to do. So, I've been giving him more independence, just like anyone else. He's, 13-year-old teenager. He has his own mind. So, mhm.
So when Emmett was going overnight on Thursdays, Fridays, and Sundays to Mr.
Mhm.
Curiel's residence, did you notice
Yes,
any issues at that time? And what were those?
I did. He had extreme exhaustion. So he comes back very angry, which is not a symptom that's normal for him whatsoever. That's that he is really just wanting to sit and be completely left alone. He was being non-responsive during school, and he's having these really bad, like anxiety attacks when I do talk about visitation, when I talk about that this is going to be dad's time. It's just, a complete kind of like, I don't want to talk about it. I don't want to think about it. So these are him not being responsive and being lethargic is not normal for him at all, to the point where when he did return from one visit, this was over spring break, right after the visit, he was exhibiting symptoms that he had when he first brain swelled, which was kind of knocking over. We were going into a store and he was kind of swaying and like he was going to fall. And so he was saying that his head was dizzy, which of course I panicked knowing that what happened the last time. So I took him to the clinic to confirm that everything was okay. They did say it was okay, probably just a little dehydration and things like that. When he is at my home, he does have to drink through a straw because if he drinks too fast, he does end up choking, and his therapist has said to be careful about aspiration. So I am, helping him with that. And also just, watching what he is eating, cutting it up into small pieces if needed. So there is still assistance that is needed in that regard. Mhm.
And Ms. Serrano, does Emmett come back from Mr. Curiel's residence appropriately attired?
No,
And how
no.
not?
Most of well, more in the beginning, he was coming back without underwear, which was what was concerning me. And he's very private and very congenial about that particular part of his body. So he's always wanting me to have it. He was coming back without it. He was, coming back with either a shirt from Eddie's, whatever, that's fine, but he has particular clothing needs. They usually have to be cotton. He doesn't like anything synthetic on his skin. So he was coming back uncomfortable. But my most concern was about the underwear. And then he was stating to me that the underwear was underwear that he had left with, not underwear that had been washed or underwear that had been replaced. Even though I I started to send clothing, but I was told to stop by Mr. Curiel that he did not need my clothing.
Oh,
So
you did attempt to discuss these issues with Mr. Curiel?
I have attempted multiple times, multiple messages. I have explained his emotional needs. I have tried in every way to help him to understand them. So all I meant with is that doesn't happen at my house. Nothing happens at my house. And I'm not going to do this, including his need to, have a routine and a schedule of me saying goodnight, and saying, kind of keeping that flow. And up until just these past two visits, Mr. Curiel was allowing Emmett to speak with me just to do a quick good night and all of those things. And now that was removed, and he could only do it on Saturday night, which I explained to him. This past weekend, he did call me. I did not call him. So he called me and I said, okay, I wasn't expecting to hear from you. But I talked to him for a few minutes, as we usually do, to keep the routine. During that call, he stopped.
Judge, I'm going to object to anything that's hearsay.
Sustain. Don't tell me anything that the child said.
Okay.
Mr. Jeffries asked another question.
Yep. Ms. Serrato, as it concerns how often Emmett calls you,
Mhm.
how often does he call you?
He calls me when he's allotted to, and then he has called me other times when he can get away. So I would say that that's basically once a night when he's in possession, or more recently just Saturday night, because that's the only time he gets access to any of his things. When he gets home,
And
when he gets
last
back.
question.
Oh, go ahead, sorry.
Okay. Last question, Ms. Serrano.
Mhm.
Have you ever called Emmett between the hours of midnight and 6 a.m. while he's been with Mr. Curiel?
No, I have not ever called him during that time.
I will pass a witness.
I just have real brief, Judge. I know we're getting on 2:30. Ma'am, the address that you gave of 895 Ranch to Market 32, I think it's space 27, Blanco, Texas 78606.
Mhm.
You realize that's an RV park, right?
I do realize that, yes.
Are
It
you in an
is.
RV? Are you in an RV right now?
I'm not at an RV right now,
Where
but
are you at right now?
right now I am at my Bastrop address. I have two
Okay, thank you.
addresses.
I'll pass the witness.
Okay. Mr. Jeffries, anything else?
Nothing further, Your Honor.
Okay. All right, and no further witnesses from your side, Mr. Willie?
No.
Okay. All right, we're about out of time, but if you want to give me a brief summation of what you believe the evidence has shown and what you're asking the court to do. Mr. Jeffries, starting off with you.
Thank you, Your Honor. I will say Mr. Willie and I agree on one thing, that a temporary order does need to be entered. I believe that the terms of it potentially need to be addressed when it pertains to possession. That's the big one. Are we dealing with a standard possession, an expanded standard? Are we dealing with the standard possession as the code lists it now, or as it was listed 2 years ago? That's one issue that I think needs to be addressed through this reconsideration. Additionally, the child is exhibiting these changes in demeanor after being with the father, regardless of whether it was 6 months ago, 2 months ago. That's a problem, and it needs to be addressed. I still think the best source of the information is going to be the child himself, because the parents have slight disagreements as to what is happening here or there. And there are various accusations against Miss Serrano as it pertains to what she's doing to allegedly alienate Mr. Curiel. So I believe that these issues need to be addressed through a reconsideration of temporary order, and definitely an entry of the temporary order, which I believe Mr. Willie and I can get that sorted if we have the court's direction on that.
Okay, just to clarify, the hearing that was held in this court in September of 2025 was a hearing on a motion to enforce temporary orders, a motion to modify, and a counter petition to modify. So the order that will come out is not temporary orders. It's a final order and a modification. It's my understanding. So y'all been kind of loose with the language that's been used here, temporary orders. I just want to make sure we're not mixing apples and oranges here.
I thought the order all the way around were temporary orders back in September. Motion to modify it was temporary. The enforcement, of course, would have been final, but the visitation increase that we requested was, I believe, temporary.
Okay. Well, Mr. Willie, the order that you circulated.
Yeah, we made a mistake on that one. My paralegal sent the wrong order.
Okay. All right. Well, thanks for clarifying. So it should be a temporary order.
It should.
Okay.
Could I make a couple
Yes,
closing
go
words?
ahead.
So, Judge, this should be clear to you. You go to September, you make a ruling. You say standard possession order, no, nothing else. We have the right to elect under the family code, the expanded 153.317. That's under 100 miles. There is 153.317 that talks about under 50 miles, but they really mirror each other with the exception of a couple things. But he's allowed to do the Thursday, he's allowed to do the Sunday. So they're humming along for 4 months. She allows him to do the expanded. All of a sudden she gets a new lawyer and it says she moves 50 miles, files something with the court and says she's living in an RV. However, today she's at the Hackleberry Act address in Bastrop. She's lied to the court. I don't know how we can believe another thing. There's no evidence from her. She's tried to take matters into her own hands by over 50 miles, but I won't give you the address. She's tried to say, CPS needs to get involved. They denied that. She tried to say she lives over 50 miles because that somehow changes the expanded standard, which it doesn't. I put a brief in the box, by the way, on that. So I think we should go with what you intended. I don't think she should be rewarded for her third or fourth lawyer on this case trying to come up with something new. And expanded should be fine. He can take care of this kid just like he found back in September.
Okay. Anything else, Mr. Jeffries?
I will just point out that I believe Mr. Willie tendered it, and the court took notice of the file as well. The big issue, like I was saying before, is what specific possession schedule was ordered. If it was the old standard, if it was a current standard, we have different bases for which to evaluate these. So I think that is the underlying basis for what we're dealing with.
The law's the same, Judge, 153.317, and he's trying to confuse the court. The law says unless you make a certain finding, which you didn't in September, he has the right to expand that. And it's not the old standard or the new. It's what the law currently says under the Family Code.
If I might jump in on that very briefly.
Okay.
I will say it may have confused the issue when Mr. Willie was referring to an expanded standard schedule versus a standard schedule. We have since, I believe, 21, this tiered schedule of 0 to 50, 51 to 100, 100 plus in the standard schedule. So that's where I think we at least have a point of confusion that exists in where we are right now. So that issue needs to be resolved regardless. And if anyone thinks I'm confusing the court, I'm coming here to get this fixed, not to confuse anyone.
Here's what the code says, Judge. Under 153.3171, if it's under 50 miles, which I think she is because she's in Bastrop, he gets the automatic right to elect. 50 to 100, sorry, 50 to 100, which is 153.317, says he gets to elect unless under some circumstance you find it's just simply not in the child's best interest. But because she's in Bastrop and it's 48 miles, the court can't, my reading, I don't think the court has a choice but to follow 153.3171, which says he automatically gets it. There's no question.
Okay. That's what's in the family code, isn't it, Mr. Jeffries?
Just a moment here. And again, that may be a misunderstanding on one side or the other. But whatever the code says, if the court is ordering a standard possession schedule, that's what we go by.
There's no such thing in the code as an expanded standard. It's standard, and then he has the automatic right to elect, which becomes what we call in the hallways expanded standard.
I understand. It seems like the confusion is with Mr. Jeffries. So, I'm a little puzzled as to why y'all are here. I think the rulings and the letter that was issued back in September of last year don't really leave much room for debate. And so I'm going to ask that you put together the order. I think Mr. Willie has at least put a draft together. Mr. Jeffries, have you reviewed the draft?
I have reviewed the draft I received a couple months back, yes, and I'd sent requested changes multiple times, and here we are.
Okay. So here's what you can do. Mr. Willie, you can email Ms. Seeger your version. If you have a red line version, Mr. Jeffries, you can send that in. The court is going to adopt the version that most closely resembles the ruling set out in the ruling letter from September.
When would you like that by?
Well, this has been lingering in my book for far too long, so let's take a look at the calendar here. May 8th would give you 2 more weeks on something that has lingered for months at this point. Can that work for both of you?
Absolutely.
Yes.
I could get it to you today.
Okay. Well, that would be helpful. So how have y'all actually had a meeting in which you conferred about the differences, the red lines, Mr. Jeffries and Mr.
I have
Williams?
tried.
Okay. It might be helpful for you to do that, and I'll let you do that offline. But when I get if I do receive 2 competing versions, I may very well just pick one that I think is closer, or I may go through and pick some language from one, some from the other. I don't know. But so this is a risk that you will, I guess, bear by not reaching an agreed order, if indeed that is the route that you go. And a reminder, we were supposed to have the order submitted back in October. So I think you may be new on the case since then, Mr. Jeffries.
Since then, yes, Your Honor.
Okay, so that wasn't your doing, but nonetheless, here we are with only a ruling letter and no order. So seeing that we've covered everything on the agenda, are there anybody have any questions before I let everyone go?
No.
No, I think it was pretty clear.
Okay. All right. Thank you. I appreciate your time in the virtual courtroom. Everyone's excused. Thank you. Take
Thank you,
care.
Your Honor.